Welcome back on The Big Question. Tonight we're talking about the ruling on Thomas Letangule by the IEBC Special Committee. The chair of that special committee was Thomas Letangule, who was also an IEBC commissioner. Thank you so much for making time.
Thank you, sir.
For The Big Question tonight. Right, keep talking to us on 22422 and on Twitter using the hashtag The Big Question on what you think. I'll start here with Omonya and Karen saying, striking Wetangula off the voters register would be a bad joke. Show me a single Kenyan politician who has not bribed voters and I will show you which color your blood is. Okay, we have Kathy Nakuru saying the ruling was political and a bad precedent. I thought we gave IEBC teeth to bite, but it seems the teeth are just to show while smiling. I'd like you to respond to that. And even this, Walter Sang saying IEBC was intimidated by political forces out to maintain the status quo. How would you respond to those first? And how difficult was it for you coming up with this ruling? Or otherwise, if it wasn't difficult?
I can say it was difficult, really, because for us, the Supreme Court did not direct us to do anything. They don't give out an order that we do ABCD, we delete. What they said is that within the law, consider. So if you look at the definition of consider, it means looking at it, having a look at it, look at the material before you, then consider whether to delete. So what materials are we to look at? It's the law. There is no other material. You look at the facts and you look at the law. We look at the law, particularly Section 9 of the Elections Act. We look at also the decision of the Supreme Court, the Court of Appeal, and the High Court. And we look based on that. Then we say the law is very clear in Section 9 of the Elections Act. It says you can either delete somebody on 3 grounds. One, whether that person is bankrupt, whether is of unsound mind, or whether the person is convicted. So then you now
convicted of
an offense.
Okay.
So now you come in and check at what is convicted. Convicted means you must have undergone through a criminal process and found to be guilty, and therefore you've gone through that process and therefore you've been convicted and either sentenced or penalized.
Okay.
So if that process had happened, then we would have had the teeth to proceed.
So in this case, you're saying what happened in the High Court, upheld by the Appeals Court and the Supreme Court, was just a finding? So because there was no conviction?
Basically because, you see, the High Court as a trial court in an election petition cannot convict. It can only find. So the conviction aspect or the criminal aspect is done by a criminal court. And therefore there must be separation. And that's why we took the trouble to look into other jurisprudence. In Ghana, what the High Court does is once they find there is a finding of that nature, there is that offense has been committed, it refers it to the criminal court to try. But the law in Kenya is not clear. So that aspect is there. I'm coming to that so that you can tell me what you propose, because this is one of the things you said in your ruling about realignment,
legislative realignment on this matter. But when you hear people like Catherine Nakuru saying it sets a bad precedence, and of course let's even forget about Wetangula because that case is done now. But going forward, what does this mean? If somebody is found guilty of an electoral offense like voter bribery or otherwise, you can't do anything to them, that's what you're saying? Because the problem in this, it has been a big problem in this country, and the framers of this constitution, the idea was to make this to make it as punitive as possible.
First, as the law was saying, as the law stands, the law is not clear on what should be done. It just creates offenses, but doesn't say what then next step should be done. And in our view, and we've proposed as IEBC certain amendments to all these laws to align it. What we are saying is that deleting somebody's name, in this case like Wetangula, is a very punitive decision. And it affects certain rights. And if you look at Article 24 of the Constitution, it talks about limitation of rights. And before you do limit rights, you must then cross-check. And therefore, the law anticipates that the person must have gone through a proper criminal process with safeguards and convicted. So for us, we're very clear. And that's why we're proposing amendments to the law. Because we're saying, once the election court, the High Court for that matter, sitting as an election court, finds that there is an election petition, our proposal is that from that point onwards, it refers the matter to the DPP to either investigate and then charge.
Which happened? They referred this matter to the DPP and the EFCC.
Yes, exactly. So what we're saying, there must then be some sort of timelines within which certain things must be done. Remember, the court also cannot direct DPP. It can only refer the matter to it for the DPP to decide what to do. So what is lacking is certain timelines, critical timelines, to say the DPP must make a decision within this period, and those must be built within the law.
So do you think it is a matter of, I mean, a lacuna in the law, or are you talking about the DPP not having done something here?
I think there is a lacuna in the law.
So it's not about the Director of Public Prosecutions
Yeah, because
office.
if you look at it, there are no set timelines and guidelines. There are no procedures. Therefore, a certain matter like it is for Wetangula can run for so long, and nobody's checking, no cross-checking by the court. Nobody reports to the court to say this is what's happening.
Right.
So, like, if you look at the presidential petitions in this country, there are clear timelines. You must file a notice of appeal within this period. It must be decided within this period. That is what we need. Yeah.
Francis Inembu says, so does that mean in the next election, and this is what I was asking, for example, if people can bribe voters, treat voters and all that, as long as there's no conviction, they'll walk scot-free. That's what you're saying.
Exactly, because at least you cannot touch the deletion aspect of it. Because before you delete the name, there must be a conviction. And that is what Section 9 of the Elections Act states. So you know this person has done this, but you cannot do anything because of... If there's no conviction, you cannot do anything about it. You see, Hussein, as long as it's just pronounced that there is an offense, and that offense has not gone through the criminal process of trial and subjected to evidence and tested, then on what basis? It just amounts to like some hearsay. That's what I mean. But sometimes, okay, this is you're saying it's a hearsay going forward. And again, I don't want to make this about Wetangula's case because you have determined it. But in his case, for example, it's not about hearsay because the matter was in court, appeals court, high court. It was found that he was guilty of voter bribery. But what you're saying is that there was no conviction in a criminal proceedings. So that's why I'm asking you. I mean, the idea was to make voter bribery extremely punitive. Going forward, that's why I'm saying let's forget about Wetangula's case, but going forward, you see somebody engaging in voter bribery, even if the court has found him or found her guilty of voter bribery, nothing can be done. That's what you're saying. Until there's a criminal... What happens is that if you look at even, let's use the Wetangula case, the High Court made a finding that there was bribery. And what did it do? It annulled the election. So it made a serious finding, and it annulled the election. What the court did not do is refer then it cannot convict. Neither did the High Court convict, neither did the Court of Appeal, and the same thing, the Supreme Court even went further to quash the disqualification. So, but it made the High Court actually annulled the election. That is as far as the election petition is concerned. And Wetangula came back and won. But what I'm talking about being punitive, and that's why I'm saying going forward, being punitive, the idea of deleting somebody from the register is to make it so punitive that this problem of voter bribery ends in Kenya. Exactly. So, and that is what we, as IEBC, we have proposed for amendments in the law.
So what do you want to be done? What do you want to be done to cure this or to...
that again the election court can revise again the law can be made such that the DPP can immediately institute proceedings if such allegations are found, and a process of criminal process must run. All we are saying is that somebody must be afforded that kind of criminal protection for it to proceed to conviction and before deletion. So the criminal process, you still think it must run? There's no other way. There's no other way around. That's the only way to safeguard people's rights. Okay. More SMSs here we are getting. I'll read this from Jomo Gigi Westlands. Wetangula being let off the hook is clear indication that the IEBC is independent, devoid of any imagined interference. Let nobody hold the notion that IEBC is out to endear itself to the opposition. Let's take a look at what you're saying on Twitter. Right, Godfrey Baraza Were, vindication of Moses Wetangula is a clear indication the government wants the opposition to have trust in the IEBC. I don't know what you think about that. Stephen Mwangi, respecting and showing confidence in independent agencies in the absence of favorable outcomes strengthens them. Gerald Depario, did IEBC overrule decisions made by the courts, or the ruling was based on law and other legislations? That's what you were explaining. And it's time to trust our IEBC and the courts. And I'll read this message here from David
Ngure Nganga Langata, Wetangula's case was a litmus test from IEBC. Did they consider they will be condemned by the opposition in case they ruled to delete his name? Can Letangule confirm it was free and fair without any political consideration?
Yeah, I think I'll go to that, the last one. You see, you're saying my committee, which has been in existence now for some time, we've been very consistent. We have handled a number of these election-related disputes. Actually, in the last election, 2013, I handled over 2,000 complaints. And if you look at it, we have been very, very consistent, even in our decision. Most of the appeals against these committee's decisions have been dismissed. So what I'm saying is that we have been very balanced as a committee, including like the famous case of Kathy. We stuck to our guns. We stick to the law and the facts. And that is our guiding principle. So nobody pressurizes us. We look at the facts, we look at the law, and we balance those interests against also the interests of particular people within the law. So we are not bothered with other factors.
He's asking that, and some people are still asking that tonight, because we have been in this country and we've seen Ford severally talking about IEBC. And whether they can be, and how biased IEBC is.
I mean, for us, if it were a question of now avenging for CORD attacking us, this was an opportunity. We should have then left the law aside and deleted them without considering, if we were that vengeful. But then we are guided by the law. And as you look at that detailed judgment, it is really detailed and explains how we arrive at our decision.
Although some would say maybe you did that to buy some political capital. That is the SMS being sent here. That you deny. Okay, so you're saying you're proposing a lot of changes.
Yes.
Why haven't we heard about this before? Why didn't you talk about this before, knowing that there could be such problems going forward? And what exactly do you propose to be done?
Actually, saying not just this particular provision on convictions and election offences. IEBC has submitted to Parliament, the Parliamentary JLC, the one dealing Justice Legal Committee. We have taken a number of proposed amendments to the laws. For example, we want them to address even as quickly as possible the timing of resignation of members, people in the civil service. We have made several amendments to align to be facing on our experience in the last election. When does nomination for primaries take place? When do we lock them? What should regulate them? So we have submitted a number of these amendments, including currently on how to deal with offences arising. So it didn't just arise. They have been pending there. Parliament is yet to do its duty. We as IEBC, we are way ahead of time, because we want to prepare for a better election than last election.
Okay.
Yes.
All right. Thomas Letangule, IEBC Commissioner, of course, the chair of that special committee that made that ruling that gave a lifeline to Code Core Principal and Bungoma Senator Moses Wetangula. Thank you so much for making time.
Thank you very much.
Thank you. Talking to us on 22422 or on Twitter using the hashtag The Big Question. We'll be right back after this break.